Hello guys, this is Sanjana Parihar, uh, intern at LEXIS and Company. I'm pursuing BLB and this is my first year. So today we'll talk about Supreme Court's judgments on preventive detention. Um Supreme Court ruled that preventive detention order can only be passed if the detainee is likely to adversely affect the maintenance of the public order. The Supreme Court also gave direction to the government and to other courts for dealing with detention under preventive detention. Preventive detention for public order, the court held that it cannot seriously be disputed that the detainee may be a white collar offender and it set free will continue to cheat gullible persons. However, a preventive detention order can only be passed if his activities adversely affect or are likely to adversely affect the maintenance of the public order. Clarity on the term public order preventive detention is a necessary evil, only the preventive public disorder, but a liberal meaning cannot be given to the expression public order in the context of preventive detention statute. Now, the directions to the government, the state should not arbitrarily resort to preventive detention to deal with all the and sundry the law and order problems which could be dealt with the ordinary laws by the country. Directions to the court. One of the questions the court must ask is deciding the legality under the preventive detentions, which should be was the ordinary law of the land sufficient to deal with the situation. Preventive detention undermines the liberty of the citizens is most important right won by the forefathers after long historical and arduous struggles. uh, Now, constitutional provision where Article 22 grants the protection to a person who are arrested or detained. Detention is of two types, namely punitive and preventive. Punitive detention is to punish a person for an offense committed by him or her after the trial or the conviction in the court, and preventive detention, on the other hand, means the detention of a person without a trial or the conviction to prevent some things that you can foresee. Article 22 has two parts. The first part deals with the cases or with ordinary law, and second part deals with the cases of preventive detention law. Now, the 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of the advisory board from 3 to 2 months. However, this provision has not yet been brought into force, hence, the original period of 3 months still continues. The Preventive Detention Laws made by the Parliament of Preventive Detention Act 1950, which was expired in 1969, Maintenance of Internal Security Act 1971, repealed in 1978, National Security Act of 1980, and Prevention of Illicit Traffic, Narcotic Drugs, and Psychotropic Substances Act of 1988, Prevention of Terrorism Act 2002, repealed in 2004, and a few more. Now, the issues related to Preventive Detention Act in India is no dramatic country uh, in the world has made preventive detention as an integral part of the constitution as has been done in India. The government sometimes use such laws uh, in an extrajudicial power. Also, there remains a fear of arbitrary detentions. So, this was all for today. If there's any question related to the content, do let me know in the comment section. I'll get back to you as soon as possible. Also, this video does not solicit any kind of promotions or advertisements. This is for education purposes only according to the Bar Council of India. And if you like the video and the content, please like it and subscribe LEXCLIQ for more videos like this. Thank you.